For judgment item number 1, CRLA 373 of 2015.
The appeal is allowed. Let the appellants be set free forthwith.
Tender matter prior to completion of the
Please
previous.
give your slip.
Lord, firstly, I am very mentioned, but the matter could not come on this today. Lots of kind of patient tomorrow, Lord. Very urgent.
We'll see. Give your slip.
Matter is reserved. Order is reserved. I want to submit a judgment. This may can't be taken in.
Sit down.
Upon writ appeal, whether the player of the appellant for participating in the recruitment examination for junior engineer has been disallowed by the Honorable Single Judge. Now the examination has been fixed to 19th of this month. Therefore, kindly taken upon.
Lordship, I may be pardoned to mention, I mean, Lordship.
All
Find a writ appeal 6 months back.
just a minute.
We had
Please give your.
Sir, I have order. Let us stop from the other side. Sir, your Lordship, I have got an urgent matter. Auction is fixed on tomorrow. I have mentioned this in this report. Several times, but this has not.
When did you make the mention?
Sir?
When had you made the mention?
On second of this month.
What happened to that slip?
That has not come up in this list.
All right, you'll see.
First, it should come up in the afternoon, sir. In the second half, it should come, but tomorrow is the option.
So,
Should be, my
this
suggestion.
is impossible.
Tomorrow, sir.
We'll see.
Sir, I filed this writ appeal 6 months back.
Please give your slip, madam.
But sir, there is no restriction.
You know, it's a fresh matter. The petition for the division of the
Please give your slip. Do you have?
yes.
All right, sir.
Lordship, I may pardon to mention, I mean, virtual
Just
Lordship.
a minute.
There is a difficulty of with the listing of this matter, the earlier date application in this appeal. The disclosure based with my UGC was there in the appeal. Therefore, this matter could not be listed for the regular bench. So it has to be listed before at least with my.
All right, all right.
Pardon to mention, I've already given my sleep here. But here you will also, the internet number 1 was.
Whether you have mentioned everything in this slip.
Yes, sir.
I
Second time I
go
tried.
through each and every slip.
Sir, the matter is very urgent matter, sir. Sir, I have filed this writ appeal 6 months back. But till now, it's not listed.
Where is your slip?
Sir, I have already given it. I may pardon me on item 20. The tender matter already infructuous, cancelled. I have filed a memo for withdrawal. I may 20 to withdraw this thing. As infructuous matter.
Lordship, I may pardon to mention, Lordship, it is a matter pertaining to formulation of Chilica policy, Lordship. I have given this slip before your vacation, Lordship. That is WPC number 7469 by 2017, Lordship.
Either
This
some
matter-
date, Mr. Counsel, you can inquire from the court master, either some date might have been fixed or your prayer might have been rejected. These are the only two possibilities.
Lordship, I will make query from
I
the.
have gone through all the slips.
Lordship,
Yes.
Weekly list item number 2. I'm sorry. For orders. Matters under the heading for orders. Item number 16.
This is the delay of 139 days, notice was issued.
Just one moment. Office note indicates that neither the postal tracking report indicates that the item has been delivered on the addressee. Since the office note indicates that returnable date had been fixed to 17/12/2024, available none appears for the respondent and the matter is called. Returnable date had been fixed to 17/12/2024. Lists the case on 13/1/2025. In the meanwhile, registry shall ascertain if any counsel has appeared on behalf of the respondent. Yes.
Item 17.
Filed a petition for condonation of delay. That is at flag
No, that
8.
is all right, but what is the subject matter about?
That subject matter is for regularization. Madam. And the ground of challenge is that
Regularization of whom? Yes, tomorrow. Yes.
Item number 18.
Yes.
18.
What is the year?
293 days.
For judgment, item number 1, CRLA 373 of 2015.
Are you opposing?
Opposing because no explanation has been given for any virus case. I will look to the
The appeal is allowed.
application for condonation of delay. Nothing has been said why
That
the
the
delay is there. That is why
Appellants be What
Oh,
is
uh,
the the order? Forthwith.
this order is annexed to one. At page. It starts from page 26.
Tender matter, prior to completion of the
Please
period,
give your slip.
From the year 1997, my lord, the petitioner working as a junior stenographer, even he is working till
We'll
today.
see.
Though
Give
he
us
has
it.
been described as the procedure is etc., my lord. Ultimately taking everything into consideration, the honorable single judge has passed an order. That since he has been continuing as a junior stenographer, not only in this office, he was deputed to the
Now the
honorable
examination has
minister's
been fixed to
chamber
19th of this
to
month.
work as a junior stenographer. Thereafter, he was sent to the Board of Revenue. Therefore,
Lordship,
taking
I may be pardoned to
everything into
mention, I mean,
consideration,
Lordship.
passed an order that the fees must be
All
regularized.
the slips.
Filed a writ appeal. That has been challenged.
Just a minute. Please give your.
Sir, I have order order. That is not from the order side.
Okay.
Sir, your lordship, I have got an object matter. Option is fixed for one thing. I have mentioned this in this report.
When did you make the mention? When had you made the mention?
On second of this month.
What happened to that slip?
That has not come up in this list.
Abolish one post and create another.
In fact, there is nobody
All
except
right,
myself
we'll
working as a stenographer from very beginning, my lord. Though the post of civil stenographer is available now, thing is that what the honorable signatures are directed. Since he has been working from 1987, he will abolish that post and
We'll see.
Sir, I filed this writ appeal 6 months back.
Please give your slip, madam.
But sir, there is no restriction.
Whether such directions
In
can
order
be
to
issued.
fresh matter, the
Exercising power
petitioner
of
for the
judicial.
division of the,
Please give your slip. Do you have it?
yes.
Whether such direction can be issued.
Lordship, I may pardon to mention, I mean, virtual
Just
lordship.
a minute. A legal question.
Which
requires,
disciplinary bench with my UGC was there in the appeal. Therefore, this matter could not be listed for the regular bench. So it has to be listed for bench with my.
All right, all right.
Pardon to mention, I've already given my sleep here, but here you will also. Intervention number one was.
Whether you have mentioned everything in this slip.
Yes, sir.
I
Second
go
time I
through
tried.
each and every slip.
Sir, the matter is very urgent matter, sir. Sir, I filed this writ appeal 6 months back. But till now, it's not listed.
Where is your slip?
Sir, I've already given.
Appeal.
I mean, pardon me.
As warned by.
I mean, pardon me, item 20, the tender matter already in process, cancelled. I have filed a memo for withdrawal. I mean, 22 withdraw this.
99.
As in process.
290.
Lordship, I may pardon to mention, Lordship, it is a matter pertaining to formulation of Chilica policy, Lordship. I have given this slip before your vacation, Lordship. That is WPC number 7469 by 2017, Lordship.
Either
This
some
matter.
An objection has been filed on behalf of the opposite party.
Lordship, I may pardon to mention,
On behalf of the opposite party to the application seeking condonation of delay on the ground that the said application does not disclose, said application is not satisfactory for this court to condone the delay, as no sufficient cause has been shown. So, top. Next, though we are satisfied that the delay in filing the writ appeal has not been properly explained, in the interest of justice and in view of the legal issue involved in the present intra-court appeal, we are inclined to condone the delay subject to payment of cost of ₹5,000 to the petitioner within 4 weeks from today. So stop. Next. It is noteworthy that by the impugned order, the learned single judge has directed for a regularization of the petitioner's service by creating one post of junior stenographer in the establishment of opposite party number
3 manner.
No, in this case.
Opposite party number 2 as per the order. Para 10.2.
Respondent number 2.
Appellant hearing.
The appellant, by abolishing post of senior stenographer. Stop. The question is as to whether such direction could be issued, in the facts and circumstances of the case, by this court in exercise of power of judicial review under Article 226 of the Constitution. Stop. List this matter for admission 8 weeks.
Item number 19. Item 19.
Appearing. No appears tomorrow. None appears for the appellant when the matter is called. In the interest of justice, list the case tomorrow.
Item number 21.
Madam, may it please your lordship. I am on VC. Am I audible, madam? Am I audible?
Yes, Mr.
Yes, madam, there is the IA 63 of 2025 for amendment.
So, Padija, your item is 21. Let us finish 20.
Oh, I'm so sorry, madam. I heard 21. My apologies. madam.
Mentioned withdrawn. So you have called 21. Oh, I'm sorry.
No, that's okay. I'm so sorry. So 21 has an IS 63 of 2025 for amendment. If your lordships remember, this matter was listed on the second, and there was a discrepancy in annexure 3. Your lordships will see in order number 1. So I had undertaken to file the correct one. So now it has been filed as annexure 3A, my lords. I have also filed a consolidated petition. Your lordship may take both on record, my lords. And then can it be day after tomorrow?
Yes. IA for amendment, IA 63 to 2025 for amendment, okay? Answering the submissions of Mr. Ashok Kumar Parijal and its senior counsel, the IA for amendment is allowed. Full stop. Allowed, the application is accordingly disposed of. Mr. Parijal and senior counsel submits that the consolidated writ petition has already been filed. Full stop. This is the case for fresh admission on 8/1/2025.
Harassment over. Adjourn matter item number 2.
May it please the Lord. The lordship in the last occasion had directed the respondents to file an affidavit substantiating the submission they have made on 19/11/2024 that the BOG had not authorized the director to file the present. Lordship kindly the affidavit.
Yes, have you filed?
Yes, madam. I have filed. Filed supported with the documents obtained under the RKS.
The present appeal has been filed by the director. IGIT, what is IGIT?
Indira Gandhi Institute of Technology.
Indira Gandhi Institute of Technology to its director. Has been filed by the Board of Governors, IGIT, Sarang, to its director. To its director.
BOG represented by the director.
When counsel appearing on behalf of the respondent has taken a plea that the BOG of the IGIT had never authorized the director to file the present intra-court appeal. First off, an affidavit has been filed on behalf of the respondents number 1 to 4 in this regard. Relevant counsel appearing on behalf of the respondents has submitted that the present writ appeal filed to the director deserves to be dismissed on listed ground alone. Stop. Next, the objection so taken on behalf of the respondents is totally misconceived and is rejected. Yes.
Place the judgment.
Yes, where is that?
The lordship that is at annexure 9. And the judgment starts from page 63. Your lordship.
Yes.
The operative portion is at page 89, paragraph 16.
Yes.
May I place your lordship?
Page
89, paragraph 16. Your lordship. Is the operative portion.
Yes.
Thus, from a conspectus of the analysis made herein before, this court holds that the claim of parity raised by the petitioners with their counterparts of UC Burla is justified. Consequently, the impugned order passed by the Secretary under Annexure 4 is held to be unsustainable in the eye of law. Having held thus, this court would make it clear that the petitioners would be entitled to the pay scale of the senior scale, that is senior teaching assistant, from the date of completion of 5 years service as teaching assistant. Such benefits shall be granted till the date they were promoted to a higher scale and or granted financial upgradation in the form of TBA / SCP or / RACP and MACP, as the case may be. The financial benefits be calculated and revised and disbursed to the petitioners accordingly. Your Lordship, for better appreciation of the facts, I have prepared a date chart, Your Lordship.
Yes.
May I read? Your Lordship, on 11/9/1981, there was a resolution passed by a syndicate of Sambalpur University to merge the pay scale of junior instructors and senior instructors of UC Burla on completion of 5 years of service.
What is UC Burla?
UC Burla is University College of Engineering. It is a constituent college. During 1981, it was a constituent college of Sambalpur University.
University College of Engineering,
Your Lordship.
the constituent unit.
It is a constituent, it was under Sambalpur University, Your Lordship, at that time in 1981.
Now,
Now it is an autonomous university, Your Lordship. It has been renamed as BSSUT Burla.
yes, what happened? Junior instructor.
Your Lordship, there was a resolution passed by syndicate of Sambalpur University to merge the pay scales of junior instructors and senior instructors of UC Burla. On 11/9/1981, that resolution was ratified by the government. Your Lordship, then in the year 1983, IGIT Sarang was established as a constituent college of Utkal University, Your Lordship. Then in 14/1/1985, government introduced the post of teaching assistant in various departments of IGIT. No promotional post was sanctioned for teaching assistants. Then, Your Lordship, on 19/2/1996, the present respondents, they filed an application before the principal IGIT Sarang to grant them promotional scale of pay to the post of senior teaching assistant on the basis of settlement made in the year 1981 for junior instructors of UC Burla. Then, Your Lordship, on 17/10/1996, the principal forwarded the representation to government for taking a decision. Then, Your Lordship, in 2003, Biju Patnaik University of Technology, BPUT, was set up, and all the engineering colleges in the state, including UC Burla and IGIT Sarang, became affiliated to BPUT. Then, Your Lordship, in 2008, UC Burla was transformed into an autonomous university. BSSUT Burla was established, governed by its own acts and statute. Then, Your Lordship, in 2009, WPC number 15856 of 2009 was filed by the respondents for early disposal of their representation, which was pending before the government. Then on 10/11/2009, this Honorable Court disposed of the writ petition. On 20/11/2009, respondents made a representation before the government. Then on 18/6/2010, government rejected the claim of the respondents to be taken over to the scale of senior teaching assistant. Challenging the order of the government dated 18/6/2010, the writ petition was filed, Your Lordship. Your Lordship, the sole point which is being raised by the petitioners in the writ petition, that they should be taken over to the scale of senior teaching assistant on the basis of the settlement
made in the case of UC Burla in 1981, and they are alleging they are stating that since their duties are similar to junior instructors of UC Burla, they should also be given the same benefits as the junior instructors of UC Burla, Your Lordship. And they are praying that they should be taken over to the promotional scale on the basis of that settlement. The Lordship may place page 79, Your Lordship. The reasoning given by the learned single judge while allowing the repetition of the page 79 of annexure 9.
Yes.
May read paragraph 11, Your Lordship. Thus, what emerges from the above reference to the settled position of law is firstly a claim of parity in pay scales based on doctrine of equal pay for equal work can be validly raised by and considered with reference to employees of two different but associated organizations. Secondly, the claim in order to succeed has to be substantiated by evidence regarding identity in all relevant aspects such as entry, qualification, nature of work, pay scales, etc. In this context, it is seen that UC at the relevant time and IGIT are engineering colleges and at the relevant time were affiliated to Biju Patnaik University of Technology. It is also seen that the post of teaching assistant of IGIT corresponds to post of junior assistant of UC, as would be evident from comparison of their pay scales, qualification, nature of work, etc. Your Lordship, I'll pause here for a moment. Your Lordship, the observation that at the relevant time they were affiliated to UC's to BPUT is somewhat not correct, because when the IGIT was set up, it was a constituent college of Utkal University. At the time of the first representation in the year 1996, both UCE and IGIT were under two different managements. UCE was under Sambalpur University and IGIT was under Utkal University. Then in 2008, UCE became an autonomous university, Your Lordship. In 2010, the rejection order was passed. At that time, UCE was an autonomous university and IGIT was under the government, Your Lordship. Then after the writ petition was filed challenging that order. That is my first submission, Your Lordship. Second submission is that here the petitioners were praying that they should be taken over from the scale of junior teaching assistant to senior teaching assistant. In order to apply the principle of equal pay for equal work, there should be the nature of duties between the subject post and the reference post should be similar, Your Lordship. In this case, there is no document on record to show that junior teaching assistant of UC, junior teaching assistant of IGIT Sarang and senior teaching assistant of IGIT Sarang were performing the similar duties.
Objection.
Those are two my preliminary submissions.
Anything else?
Your Lordship, I have the judgments to support, Your Lordship. Your Lordship, the first judgment is 2010 5 SCC, page 225, Your Lordship. Your Lordship may kindly turn to paragraph 25 of the judgment.
Yes.
Paragraph 25 at page 233, Your Lordship. May I read, Your Lordship?
Yes.
As noticed above, one post which is considered as having a lesser pay scale may be assigned a higher pay scale, and another post which is considered to have a proper pay scale may merely be assigned the corresponding revised pay scale, but not any higher pay scale. Therefore, the benefit of higher pay scale can only be claimed by establishing that holders of the subject post and holders of reference category posts discharge duties and functions identical with or similar to each other, and that the continuation of disparity is irrational and unjust. Lordship, the second judgment. Lordship, the second judgment is 1989 4 SCC, page 549. May I read paragraph 11, Your Lordship, at page 464. Paragraph 11, Your Lordship, at page 464.
Yes.
In the light of the aforesaid principles, we may now consider whether the equality claims of the petitioners could be allowed. We have carefully perused the material on record, given our anxious consideration to the question urged. From the averments in the pleadings of the parties, it will be clear that the corporation has no regularly employed carpenters. Evidently, the petitioners are claiming wages payable to the carpenters in government service. We did not think that we would accept their claim. In the first place, even assuming that petitioners' jobs are comparable with counterparts in the government service, the petitioners cannot enforce the right to equal pay for equal work. Now comes the relevant part, Your Lordship. The discrimination complained of must be within the same establishment owned by the same management. A comparison cannot be made with counterparts in other establishments with different management or even in establishment in different geographical locations, though owned by the same master. Unless it is shown that there is a discrimination amongst the same set of employees by the same master in the same establishment, the principle of equal pay for equal work cannot be enforced. Your Lordship, so basis on these submissions, I humbly pray that the respondents not be allowed to be taken over to the scale of senior teaching assistant after completing 5 years of service as junior teaching assistant.
Yes.
May I please? Because delving into the merits of the case, I just want to draw your Lordship's kind attention. This is the bylaws of the Indira Gandhi Institute of Engineering and clause 13 at page 9, the power and duties of the board.
Clause
Page 8, started from page 8, powers and functions of the board, serial number 13, subclause 13, X triple I. X triple I. My lord got it, page 9. Page 9.
Yes.
The board has to initiate and defend all legal proceedings on behalf of the society. The board has the power. Then the board can authorize any person. But here, in the information obtained under the RTA Act, the director.
That submission we have rejected already. So you don't.
Then I don't have to pray on that. On merit, I have to do.
Yeah.
Obligement. Highly appreciate. Then my learned friend submitted that nature of duties are not equal. I have highlighted for better appreciation of this board, and some relevant dates was not placed by my learned friend. Then your Lordship may please to have a glance. 1, 2, 3. The board of the governors, serial number 4. The board of the governors of the Saranga in board meeting date so and so examined the issue in detail and being satisfied that the petitioners are being identically placed like that of senior instructor of UC Burla, sent the decision recommendation of the BOG in respect of the present petitioners to the government for approval. Page 4 and annexure 8 of my writ petition. Before your Lordship, document is readily available before your Lordship in my writ petition at page 4. Then your Lordship, second, serial number 5.
Anomaly committee, there was committee was constituted specifically for this purpose. Anomaly committee consisting of principal of all the government engineering colleges under chairmanship of additional secretary to government recommended for equalization of pay scale, that is to extend the service benefit of UC Burla to IGT Sara. This is an annexure 11 series as page 35 of my repetition. Then your serial number 6. Principal IGIT Saranga, now the director, who is the petitioner before your lordship, the director, in continuation to his earlier suggestion under Annexure 15 dated 4/2/99, by letter dated 98, requested the state to pay the scale pay to the petitioners at par with UC Burla, Annexure 14 at page 9 of the rejoinder. I have filed rejoinder in my petition. Then, your lordship, this is important, page serial number 8, date 2/9/2005.
One moment.
Oblate.
Where is the rejoinder? When did you file the rejoinder, Mr. Mahanti?
Rejoinder to my writ application, ma'am.
The rejoinder, how can you find a rejoinder to your return?
To place certain document after filing of the counter
What is the meaning of rejoinder?
Not here before the single judgment.
We understand.
Obliged.
How can you file a rejoinder to your writ petition? You can
No,
file
to
the
the counter,
rejoinder to the counter
there is
affidavit.
slip of law.
All right.
To the counter.
The writ petition.
Where is that?
I have filed before sufficient before.
All right. Yes.
Then your lordship may please to have a glance serial number 8 in date 2/9/2005. Registered BPUIT, Biju Patnaik Institute of University and Technology, under which both the engineering colleges are now administered, in compliance to the government order under Annexure 12 series, submitted their views by holding that the junior inspector of UC Burla and teaching assistant of the IGIT Saranga has same entry qualification and same job responsibility. What my learned friend now clarified that the job responsibility is something different, they are not eligible. This is the main ground of attack in this present writ application. But this is the letter under Annexure 12 series at page 41 of my writ application that both are discharging similar duties, similar job responsibility, similar entry qualification. Then petitioner submitted requested this one good. Then
Yes.
and last point is that the present the board of the the secretary who filed the writ appeal before this honorable division bench is not a party to my writ petition. Is not a party to my writ petition. Here the application filed by board of governors represented through the director. Previously it was secretary.
Your petition was not maintainable. You have not read the board of governors as opposite parties in your writ petition.
No, because your lordship may have a glance to my writ petition at page 64 of this writ appeal. Page 64. Page 64. State of Orissa referring to Government Department of Industry, Principal Secretary to Government Department of Skill Development.
So is it your contention that if there is a necessary party and you have not arrayed the person as a party, they cannot challenge the order if it is agreed by the order?
He can challenge, but he has to satisfy that he is not a party. But the essential requirement is that he has to. And the second point is that who is the present director, present appellant before your lordship, he was the principal earlier. The said was re-registered as director. And time and again recommended the case of the present respondents 1, 2, 3, 4 for upgradation of their scale of pay to that of senior. Not once, on several times. I have reprinted, I have mentioned all the things clearly in my date chat.
Yes.
The lordship may reply to only the.
Has he finished? You have finished?
Minor.
Lordship, the letter issued by the chairman of BPUT, your lordship, what my learned senior referred to, the letter dated 2/9/2005. In that letter, what was the communication to the government was that the teaching assistant, junior teaching assistants of IGIT Sarang and junior instructors of UC Burla. They were performing the same duties. What my contention before your lordship is, when a certain employee is taken to a higher scale of pay, here in this case, the junior teaching assistant were directed to be given the pay scale of senior teaching assistant. The nature of duties between junior teaching assistant and senior teaching assistant should be similar, your lordship. And in case of UC Burla also, your lordship, when that settlement was done, the reason for making that settlement was junior instructors of UC Burla and senior instructors of UC Burla were performing the same duties. In this case, there was no document to show that junior teaching assistant of IJT Sarang and senior teaching assistant of IJT Sarang were both performing the same duties.
So, but how do you distinguish between the function of junior teaching assistant and senior teaching assistant?
Your lordship, the functions may be somewhat similar, your lordship, but in this case they were under two different managements, your lordship. Their entry qualifications were different. They were like their pay scales were different, and therefore, your lordship, when the two employees are under two different managements, the principle of equal pay or equal pay for equal work will not be applicable, your lordship. It has been laid down in several judgments of the Honorable Supreme Court, and principles have been established, your lordship. So in this case, at the relevant time, both this set of employees were under two different managements. One was Sambalpur University and other was Utkal University. In the year 1996, when the first representation was made, and when the writ petition was filed, your lordship, during that time, Burla was an autonomous university, and IJT Sarang is under the control of the government, your lordship. They were not affiliated to BPUT, your lordship. BPUT only for a short period of time in 2003, your lordship, they got affiliated to BPUT, but at the relevant time, they were not affiliated to the BPUT, your lordship.
Just want to draw your lordship indulgence to annexure 8 of my writ application at page 29.
Yes.
I just want to draw your lordship's kind attention to annexure 8 of my writ application at page 29. This is a document where the board of the governor principal, the president director recommended to the state government. The board discussed on the representation of the teaching assistant, junior engineers, technical development.
In 2010, the order was passed, the order of rejection.
Minor.
This IGIT was under which university? In 2010.
IIT Saranga, at that point of time, he was under the Biju Patnaik University of Technology.
Biju Patnaik University.
Minor.
And UCE Burla?
Is also under BPUT.
Your lordship, that is UC Burla in 2008, it became an autonomous university.
What is what we want to know?
This is autonomous university brought under the management of the state government. Both the colleges are, the UC Burla and IGT Saranga are two government-run managed engineering colleges, degree engineering colleges.
It's all right, under the state of Orissa, but was it under BPUT? That is what we are asking.
Initially, that was not BPUT.
That is what, that is why we wanted
but
the dates.
since
That is why we wanted the dates at that relevant time. So please mention when it came under.
Your lordship, I am just now giving the date. That is
Let me come to
prior to 2000, because in the year 2000, IGIT Saranga recommended the method to BPUT, and BPUT was also.
Mr. Mhanti, he has given a date chart giving the dates.
We'll hear it tomorrow. Yes.
Item 3.
Tomorrow.
The date regarding when it was
No, he has mentioned the dates. If there is anything, you point out.
See, that is one of the important questions.
Hopefully, I have understood.
See, your claim was rejected in 2010.
Right.
So on the date of rejection, whether both the posts were under the same establishment or not. That is, this is the argument which has been advanced.
Yes, okay.
Item number 3.
And in this case, after your lordship's direction, the register deputy, since it is not possible to hold a board meeting immediately, register deputy should mail to all the member of the board to submit their view on the issue matter. I have submitted this. And the date is fixed to 7th January to submit the view. That is at page 4.
Can we get a better scan? Judgment would have scan.
So you will have hold the meeting on 7th.
My lord.
But we will hear it on it.
Member are requested to submit their view on the issue. That is to consider approve the proposal for inter-college transfer of Kumari Bhagyalakshmi Mahathi from Synergy Institute of Technology, Dhenkanal to GITF Autonomous College, Bhubaneswar on medical ground. This is the agenda, and the members are requested to submit their view by 7th January. Next week, my lord, I will.
Mr. Parthasarathy Nayak, Learned Council representing Biju Patnaik University of Technology, Odisha, Rourkela, has submitted that which board is this? That views of the members of the board management.
Board of Management of Deputy.
Management of DPUT has been sought by 7/1/2025 on the question of inter-university transfer of the petitioner in inter-university, sorry, inter-college transfer of the petitioner. Top is this matter on 8th within first 5 cases.
Both they manner because
In fact, we are also trying to understand.
one day, 9th, because you have to submit a report to me.
No, let it come on 8th. On 8th, we can adjourn to 9th. We are also watching how the private institution has behaved in this case, and now how the university is proceeding in the matter. Let us see. So the matter will be taken up on air. On air, if you have any problem, we can adjourn it to 9. But considering the urgency, yes, it will be taken up on air.
Order may be uploaded in post of the day so that I can communicate.
Within half an hour. Type करो.
Among top 5.
Yes.
Item number 4.
Retaining the. No,
One time. I'm appealing for respondent 1 year. I paid for the time check number 1 week after. I'm not after the relationship.
Which item is this?
Item 4.
As requested on behalf of the respondent.
And
Yes. Press this matter on 2 weeks.
This is item 4.
Yes. Item number 5.
I, my lord, on the last appeal, you also wanted me to bring this is a identical matter you also have already heard. Only I beg excuse, my lord, while making photocopy both the sides, madam.
No problem. The consolidation of school.
Yes, you also asked me to come in.
Is appearing for the other side. One is appearing. Is it delay?
Nobody's name has appeared.
Despite service of notice, there is no representation on behalf of the respondent. No stop. No, we have no by order dated when the matter was earlier taken up on 9/12/2024. It was directed to be listed on 16/12/2024 for press admission when the question of limitation was also 6/12/2024 for considering the question of limitation also. It is next, it is evident on 23/12/2024. Again, the 24, the matter was listed for orders. Stop. In such view of the matter, since the matter was earlier directed to be listed for admission, this court had directed this case to be listed for admission on 6/1/2025. So accordingly, this appeal has been taken up today. Stop. Despite service of notice, there is no representation on behalf of the respondent today. Also, stop. Next, after having in the present inter-court appeal, decision of the learned single judge dated 4/5/2021 in WPC number 27401 of 2020. Same judgment, same order. Same. No, another matter. Same order is under challenge. And analogous matters and batch, including WPC number 8705 of 2021 is under challenge. Is under challenge. So top, the said order of the learned single judge has been set aside by a judgment of coordinate bench of this court dated 29/10/2024, passed in WA 417 of 2021. Stop. Accordingly, this appeal is allowed in terms of the said judgment dated 29/10/2024, passed in WA number 417 of 2021.
Item number 6.
I'm appealing on behalf of OP number 1, 2, and 3. One week time to file objection to the condemnation.
What is the delay?
Delay more than 2 years.
2 years.
738.
700.
738 basically.
So you are how much time?
1 week.
However, in this present case, no counter affidavit, no opportunity of filing the counter affidavit was given to us.
Then you could have challenged that soon thereafter. Why did you wait for 2 years? All right. As requested on behalf of the respondents.
1 to 3.
Respondent. This matter on 2 weeks.
Item number 7.
On behalf of Disciplinary, respondent number 3, and in second sub-item, madam, with respondent number 5, I pay for 2 weeks time.
Why 2 weeks? By 2 weeks.
For 2 days, for last 2 days, he's suffering from people. So today is not ready.
All right.
The accommodation. Is he on accommodation now? We are granted time on 20.
Far as item number 1 is concerned, my learned senior is appearing, Mr. Tushar Paul, sir. So far as item number 2 is concerned, there is some delay. And other item, first sub-item, delay has been considered. In the second item, delay has been, my learned senior has raised a point that that Lakshmikant Kaur, who is the law consultant, which no authority to sign the limitation fixer. So far as item number 1 is concerned, both are same.
Will let both the matters come to 2 weeks?
How many days delay?
64.
64 days.
64.
Yes.
Mr. Counsel.
My learned senior is raising objection. In other cases,
No, we are condoning it.
So like that, 64 days delay, we are condoning.
Well, delay is not a matter in the appeal. Delay is not a matter. The person who has signed the Vakulatnama and the swear affidavit, I have challenged my objection that he has no locus standi at all to file such an appeal. Because OSFC is the appellant here. And OSFC represented through the managing director. Managing director has not filed the signed Vakulatnama nor swear affidavit. A person, Lakshmikant Kaur, claims to be the law consultant
That
of
can be
OSFC.
seen at the time of final. That is a point which you can take at the time of final
But
adjudication.
the affidavit sworn in support of the delay matter,
All right, that will be decided.
and there is no authorization at all.
Yes, we note your objection and keep it open to be argued at the time of admission. All right. But since it is 64 days, we are allowed.
And there is, the appellant has not filed the authorization even to show that he is competent enough to file such an appeal. And in the last 2 occasions, they have tried for time to obtain that authorization.
3/1 of 2024. This appeal is brought by limitation. There is delay of 64 days in filing the appeal. First of considering the facts and circumstances, IE number so and so is allowed. The delay in filing the appeal is condoned in the interest of justice. Next, WAS and counsel appearing on behalf of the petitioner has raised objection over the maintainability of the present intra-court appeal on the ground that the person who has filed, who has signed the Wakalatnama has not shown the affidavit. Has not shown the affidavit.
So, he is a competent man
Person who has signed the Wakalatnama is not competent
to file the appeal.
to represent the corporation that you want to say or file the appeal.
Who has signed?
One Lakshmikant Kaur, and in the affidavit he declared that I am the law consultant of OSFC man. Under that authority, he has signed the Vakulatnama.
Section 43A.
Under that authority, Madam, he has signed the Vakulatnama and also swear the affidavit in support of the limitation itself.
The
But his age is 66 years.
He is consultant. Otherwise, that will loss.
Exactly, loss.
behalf of opposite party.
But he cannot represent
The
OSFC.
respondent has submitted that the person who has signed the Wakalatnama and shown the affidavit does not have competence to prefer the writ appeal on behalf of Orissa State Financial Corporation. So, the said submission shall be considered at the time of final adjudication.
Been admitted.
2 weeks.
Item number 8.
This case, one week time, Colonel AG wants to this matter with any connected read petition or pending. So I have taken consent of Mr. Roth and Mr. Albert at next week.
as requested on behalf of the respondent state offering.
One week.
1 week.
We have given you 2 weeks. Double.
1 week.
Yes, sir. Yes, sir.
We have submitted our proposal. Lordship has asked them the question to satisfy your lordship. Do we have some interim there?
What is this matter?
External audit conducted in complete violation of Cooperative Society Act.
Item 9.
Melody, in item 9, I was directed to file an affidavit. Although it is already ready, my lord, in course of the day, I can file it. If our lordship calls it day after tomorrow or tomorrow.
As requested on behalf of the. On behalf of.
I am for opposite panel 2, 3.
The opposite party number 2.
2, 3, 4, 5.
2, 3, 4, and 5. Plus this matter on. A week.
Item number 10.
This letter has been directed in the earlier occasion to the petitioner, file an affidavit to show his bona fideness. Last occasion was directed to the petitioner.
Affidavit is there. Affidavit is filed today.
Affidavit you have filed. When did you file the affidavit?
Now, because it's got.
File it in the registry.
And copy of it.
I'm sorry.
The council appearing on behalf of the petitioner states that he will be filing an affidavit. The light of order dated 2/12/2024. 24 in course of the day. Let it be done. This matter on 2 weeks. Yes.
Item 11.
Can be taken off for one day.
When?
My senior is not in station.
Come up and mention, so there is no urgency.
Why do you file mention slips?
My senior is not today in station, so I'm not ready today.
I requested on behalf of the petitioner on the ground of illness of learned counsel. This matter on 2 weeks.
Item 12.
Wait weeks time because some development arose in between. Wait weeks time for something.
Why do you make a mention? We shall not entertain any mention slip now.
Other listing of other matters.
That is because of some development.
This matter has been listed out on a mention having been made on behalf of the petitioner. Stop today, an adjournment is being sought on behalf of the petitioner on the ground of certain developments in the meanwhile. Stop this matter 8 weeks.
Item 13.
The petitioner here challenges the tender process. Precisely will be on three grounds. The tender process is challenged. Petitioner is an intending bidder, wants to participate in the bid by forming a joint venture. Now, this particular tender, if Lordship see, it's a highly skilled tender with regard to transport mining of sand for the purpose of segregating rare earth that is required for atomic and other things. It's a highly skilled tender. Rare Earth of India, that Government of India, IREL, Indian Rare Earth Limited is the principal agency who has quoted this tender. The first round on which I am challenging is the successful bidder is the single tender here. The tender condition has been modulated so as to tailor-made conditions so as to fit the criteria of that single bid. Single bidder, the process as contained in the JFR rules, that has been violated. That's my first condition. Second, I have taken the ground of Article 14, violation of Article 14, for Lordship see page 43 and 44 of my brief. That clause 8.44 and 43, Lordship sees clause 8.3.14. That's a clause that says, in case of a joint venture.
My lord, I have instructions to appear for the OP number 1.
Similar matter, I think, was listed earlier. You had also appeared saying you want to take.
No, that was a PIL, my lord.
Saying that, but regarding
that
this,
was a PIL, my lord. Here, what has happened?
No, but you're saying that nothing has been finalized. We have not taken any decision.
Yes.
Thereafter, this tender was floated.
That tender was challenged in that PIL also.
Yes, this same tender.
The same tender.
But in fact, I didn't know that about PIL. I didn't.
In fact, what has happened, my lord?
Verified. Yes.
My senior can submit, and then after that.
Yes.
But if my learned friend wants to, I'll serve him a copy, or Lordship will hear it.
So you have what has happened, my lords?
Now, have you been
4 months after the last date of submission of bids, this writ petition has been filed. Prior to this, the writ petitioner had approached the Honorable Bombay High Court. This is the withdrawal order. It was argued on the point of locus of the petitioner, when he has not participated in the pre-bid meeting also, not submitted any tender, and there is no irrationality in the tender conditions.
That I'll satisfy.
No specific averment that this tender condition is unreasonable or irrational.
So far as the let me learn friend say I'll
The order dated 14th December 2024, my lords, before the Bombay High Court, and this was also filed on
The simple withdrawal.
Withdrawal, because after arguments on the point of locus, the petitioner withdrew the writ petition. Even this writ petition was filed on 21st of October 2024.
Which, the present one?
No, this Bombay High Court writ petition.
No, that's not right. That has been withdrawn.
No, but when was this writ petition filed?
Present one?
This writ petition was filed.
Present writ petition, my lords, end of December something.
18th of December. But if I can address your lordship now.
Just a minute. 18th of December 2024.
Right.
This writ petition was filed. And when was the writ petition filed in Bombay?
But Bombay High Court writ petition, the date of filing, that I have annexed that order, that is at page 515. One second. Annexure 8, 515.
Same order which he has read.
That the same order I have filed before
when
my
was the
lordship.
writ
Annexure 8,
petition filed?
When did you file it?
But the date.
21st of October.
21st of October. If you like to submit, then submit. 21st of October 2014.
You had 2024, you had filed.
Correct.
And about 2 months thereafter, you filed the present writ petition.
But I withdrew it on 14th of December 24.
That is the first date or after few days? That was on the first date you have withdrawn.
No. Initially, Honorable Bombay High Court was pleased to issue a notice, rejected our interim prayer. Thereafter, I'll address your lordship about that Bombay High Court order, subject to lordship will see why I have withdrawn it. It's not the question of locus, it's a question of jurisdiction. Page 39, if your lordship would kindly see, clause 5.3. But in the tender condition, there is a specific stipulation as to jurisdiction of the court, which will deal with the matter. That came before us, and that we are confronted in the counter that Bombay High Court did not have jurisdiction to entertain this.
Clause?
Beg pardon, clause 5.3, page 39. It's not that locus. But should I place it now?
Just.
Courts and
Right,
good nature Odisha.
right. So Bombay High Court did not have territorial jurisdiction over the matter. That we are confronted the same in the counter affidavit filed by.
All right, you accepting notice.
My lord may see,
You don't want to accept notice without a wakalatnama, you want to
my
accept.
lord.
Which one notice? Accepts notice. How much time will you take to file affidavit?
3 weeks.
4 weeks?
Great.
Yes, 4 weeks. Let counter affidavit be filed.
So you have appeared or you will appear?
I'll appear. I'll appear.
Sir.
I'll file the wakalat.
As instructions.
Item 14.
Lordship speaking for counsel. Item 14.
Yes.
My lord, pursuant to Lordship's order, my lord, the chief engineer has taken steps for implementation and for passing the appropriate order. But I have received the instruction, my lord, Lordship can have a perusal to this, the last 2 lines. That the decision has been forwarded before the government for approval. Lordship directed to take a decision on the question of blacklisting. And the chief engineer in the meantime has taken the decision, but as per the OPDW code, OPWD code, the government's approval is needed. The first page, last 2 lines. First page. It may be noted that under the provision of the OPDWD code, chief engineer cannot take any decision in blacklisting matter without prior approval of the government. In view of the above, time may be granted for taking the final decision. So therefore, with the approval of the government, your lordship's order will be fully complied with.
This order was passed in 2023. 24 in 2024, 29/4/2024.
Yes, ma'am.
And you have not taken any decision. All right, you're free not to take any decision. But there is no order of blacklisting as on date against the petitioner. Even after quashing of the order of blacklisting, you are giving effect to that order, then you are liable for contempt, even if you comply with the order. Now,
No,
are we clear?
no, lordship direction is at
See, there was an order of blacklisting. That order has been quashed. You have been given liberty to pass a fresh order. That order you have not passed. But in the meanwhile, after quashing of the order of blacklisting, if you are still giving effect to that order of blacklisting, then you have committed contempt of court.
2 aspects. One, it has been set aside. Second, you have to take a fresh decision. You don't take a fresh decision, he doesn't mind. Because that order has been quashed. But if you, do not implement the order.
The paragraph in your lordship direction. Para 8 is the direction. In view of the above, the order impugned dated 17/3/2000.
So there is no order of blacklisting against the petitioner as on date.
The order of blocking portal is liable to be quashed and are hereby quashed, and the matter is remitted back to the Chief Engineer, Odisha, to pass appropriate order by affording due opportunity of hearing to the petitioner. More so, the so-called reply filed by the petitioner has to be taken into consideration while passing. Apart from the same, the authority shall also take into consideration the cancellation of the.
Is this your case that the blacklisting order is being given effect to?
Yes, my lords. My portal has been blocked. Blacklisting order, even if passed, my portal has been blocked.
Just a minute. Has the blacklisting order been passed, or without passing that order, your portal has been blocked?
First, my portal was blocked. Blacklisting order was passed. The order was quashed. Blocking the portal was quashed. Still, they are not allowing me to participate in tender.
No, blacklisting order. Last one.
Just.
Order of blacklisting. Wait. 17/3/2023. So you are in contempt. So please come to paragraph 8.
Paragraph 8.
The order of blocking of portal. This has been quashed. What was the order or date of blacklisting? 17/3/2023.
No, minutes. The date was yes, 17/3/2000. Yes. Portal is blocked in 2022. As on date, no blacklisting sustains, but I cannot drop a bid because my portal is yet blocked.
Both have been quashed.
Yes.
Lordship may grant me this week, my lord, I will file a specific affidavit whether the portal is blocked or not. Because I have no instruction on that, my lord. Only instruction
appearing on behalf
only
of
instruction, my lord, that
Just.
the counsel appearing on behalf of the has submitted that despite this court's order, the petitioner's portal has not been unblocked, and therefore it is, and therefore petitioner cannot participate in any tender process floated by the state of Odisha.
Yes.
Floated by
even other instrumental is also not giving any order to me because I'm blacklisted by state of Odisha.
State of Odisha. Stop. The order of blacklisting dated 17/3/2023 has also been set aside by this court by order dated 29/4/2024, passed in WPC number 33515 of 2023. So stop. Paragraph 8 of the said order reads thus. So stop. Next, we are of the prima facie view that if the statement which has been made by the petitioner to the effect that despite the court's order, the portal has not been unblocked, comma, it constitutes a gross case of a gross contempt of this court. Stop. list this matter on next week, so as to enable and council and AGA to seek instructions on this aspect.
I will file an affidavit to that.
Shall we vote?
Well, Lordship, I call this matter in 15th of 15th. The Lordship fix up the date.
50 and paragraph 80.
On 15th, the Lordship is
13th.
15th.
13th. Next week. Next week is when?
Next Monday is 30th, is it 15th, then 14th? 15th.
Next week is, no, 13th is holiday.
No, next day is not holiday.
14th is holiday. Well, Lordship,
Let it come on
15th, not 15th.
15th or
15th. Much.
Item not 15.
May I please, Madam? Let this honorable court has passed an order on 30th July 2024, Your Worship, directing the opposite parties to create, to constitute the common cadre, which has not been considered.
Common cadre has been created, my Lord. I have got the gazette notification and Lordship may kindly have a glance.
See the notification.
My Lord, the notification they are talking about is on.
Let me tell you.
I have a copy.
Yes.
At the 25th July, Your Lordship. Your Lordships had passed this order after perusing that document. That it is not a common cadre.
On the date of passing of your Lordship's order, this could not be brought to your Lordship's notice. But in the meantime, may I submit? So just after let my Lord friend submit, I will.
My Lord, this particular document was placed before Your Lordship, and Your Lordship had snapped back and then they had tried to pass it off as the common cadre. Your Lordships had said that this is not the common cadre, and Your Lordship would kindly peruse Your Lordship's order, where they have undertaken that we have started the process. Therefore, Your Lordships had said that since the process has begun, complete the process in 3 months. Your Lordship, there is in WA, in the counter affidavit they had filed, this particular document is present.
That order dated 37, there is no mention regarding this.
Yes, the document was placed.
No, there is no mention in the order regarding this.
No. This document was placed before Your Lordship by the public. I think Your Lordship may kindly have a look.
This is CONTC 7407.
Yes. There's an order on 37. In the writ petition. In the writ appeal. Paragraph 5. Steps have been taken. You think we are not aware that steps have been taken.
So you are alleging violation of which order?
30th July, Your Lordship.
So what is the order?
The order was to constitute the common cadre within 2 months.
So it was already done.
No, my lord. That is what I am trying to bring to Your Lordship's hand notice. That they had produced this resolution before Your Lordship. This resolution that they are now producing. And they have tried to pass it off as a common cadre, which Your Lordship rightly caught them and said that this is not the common cadre. Therefore, Your Lordship directed them to constitute the common cadre. This is just the resolution.
No, where is the direction? There is no direction. The only direction is to constitute a common cadre. That's all.
That is.
Steps have been taken.
This is the resolution which they have said that this is the step we are taking. Therefore, Your Lordships directed that constitute the common cadre within 2 months. This resolution, they said that is the first step we are taking. Now they are saying this resolution is the common cadre. After 30th, nothing has been.
Preferably within.
After 30th, before 30th, it was already done.
No, that is what I am trying to bring to Your Lordships.
No, point out, you are saying this is not.
Your Lordship had perused this.
No, let us peruse it again today.
Mr. First, please read the first paragraph.
Mine.
You can challenge that if you are not satisfied.
Lordship may kindly see the order dated 37/2021.
Just a minute.
We are looking at that.
Premlata Rautre, Lordship has already dropped the contempt.
That is what they that is what they are trying to do, Your Lordship.
You can challenge that. No case of intentional disobedience.
This particular order, this particular resolution, they have brought before Your Lordship, which Your Lordships are perusing.
That we are. You cannot depend on our memory.
They are trying to pass it off as the common cadre,
which your lordships rightly held that this is not the common.
No,
And this is not the common category.
no, we cannot say that.
And
We have not said that.
that is why your lordship said that steps have been taken, let the common category be constituted within 2 months. On 30.
The petitioner in the present contempt application has alleged disobedience of an order dated 37/2024 passed in WA number 554 of 2024, whereby the writ appeal was disposed of with a direction for preparation of with an observation that let the preparation of common cadre be expedited and completed preferably within 2 months from the set date. Stop. Next, learned AGA appearing on behalf of the petitioner has submitted, opposite party has submitted reference to a resolution dated 25/7/2024 that a common cadre of teachers / lecturers has already been constituted. Full stop. Learned counsel appearing on behalf of the petitioner has submitted that no step has been taken after the order of this court dated 37/2024 for constitution of a common cadre. No stop. Next, we are not inclined to proceed in the present contempt matter, since in view of the clear stand on behalf of the opposite parties that common cadre of teachers / lecturers appointed or recruited against direct payment post of non-government aided colleges has already been constituted.
Everyone, 30 seconds, my lord. When this particular resolution was placed before your lordship, and your lordship held in that this is not the common cadre and directed them to constitute the common cadre within 2 months, I prayed before your lordship that a direction will be issued because they are mixing up junior lecturers and lecturers. Your lordship then held that let them constitute, then you come.
Therefore,
that is what
now you can
they have not constituted.
It goes without saying that the petitioner has grievance against constitution of the common cadre. He shall have liberty to take appropriate steps in accordance with it. Yes.
Item number 22, annexure 1, the learned signatures have relied upon a judgment in WPC number 19951 2020. This is challenged and pending before the Honorable Supreme Court. The next date as per the case status is showing as 7/1/2025. However, the one point that in that matter, that was with respect to data entry operators, but in the present case, the case is regarding sweepers who were appointed on a daily wage basis.
Regarding?
Regularization of the
sweepers.
Yes.
In fact, there is a decision rendered recently by the Supreme Court.
Yes, my lords.
So all regularization matters should be taken up in the background of what has been held by Supreme Court recently in two separate decisions.
I have the copies. Only limited submission in with respect to that is that they have tried to take a departure from Uma Devi's principle.
Exactly.
My lords, only difference is that Uma Devi is a 5-bench judge matter where 4 criteria were laid down. Now,
but everything will have to be addressed.
Yes, my lords.
Now, in view of the latest one, we'll have to
be heard. Yes, my lords.
Every aspect.
Trying to prepare a compendium of all the judgments.
Please do it. That is very important. So when should we take up the matter?
Next week. Next.
You are aware of that judgment?
Yes, ma'am.
Malas, I have the copy of the judgment.
What is the name of the party?
JAGO. Jago.
Jago.
Yes, ma'am.
Yes. Yes. Yes, yes.
Jago and one more judgment, Vinod Kumar. These two recent judgments of.
That Jago was December, I think.
Yes,
There was
ma'am.
another
December.
Justice Suryakant before that also.
My
So
lords,
all those has to be.
In Justice Suryakant, what was held was policy of the government has to be given to all the members similarly. These three are the judgments of the 2020. However, there are judgments of the year 2020, 2021, which talks reversely to what has been
By
held.
the time we come.
No, but we are bound by Jago. Jago will bind us because all the judgments have been considered. Whatever has been held, we will have to follow.
And it's humbly in Jago, all the judgments have not been considered.
Not been considered. All right.
That we will come to the
As jointly requested on behalf of the parties. This matter on 3 weeks. They meet by
Item 23.
I'll take the stretch 2 weeks. Yes.
Item 24.
3 weeks time may be granted, my lord.
3 weeks.
Item 24.
Didn't got the opposite party number 2 matter. And five the counter affidavit matter, so style may be fine.
That what happened in this case, the revenue divisional council has extended the time to lift the shortfall quantity of the minerals. The particular time was granted, your lordship, and see, your lordship's order dated 27/3/2025. That is 16 months, 15 days. Time was granted in 2023. In the meantime, that time has lapsed. And he is being permitted to lift up minerals thereafter.
You are referring to which order?
That order dated, order number 3 dated 27/3/2023. The last second paragraph your words stands. And that period has been over from July 2024.
In this case,
Just a minute. At the outset, he mentions
And by a subsequent order dated 7th February 2023, the time period for extension of the lease in question has been specified as 16 months and 15 days from the date of submission of the waiver, and that the lease agreement has accordingly been executed. 2015, the original lease.
This order dated 7/2/2024 for my
And
lunch.
then your lordship's order dated 8/2/2020.
This time limit has been, this order has been caused by this honorable court in WPC number P7557 of 2023, madam.
which order?
This order 7 February 2023, wherein the time period has been fixed for 16 months and 15 days. This order has been caused.
Where is
This
that?
is the relevant order.
Yes, do you have this idea? Do you have any idea about this order?
About that order, I have no idea.
we are filing a.
Since Sagat was subject matter.
Yeah,
the
you must
case and
file your lordship.
Lordship may call this matter along with that. Sir.
Yes. What is the effect of
Thereafter, my lord, the Revenue Divisional Commissioner passed the order, my lord. And he was allowed at the Revenue Divisional Commissioner order dated
See,
10.
now since because of the order of this order 26/4/2024, 27/3/2023 becomes meaningless.
Yes, ma'am.
Any extension granted also becomes meaningless.
Extension granted also became meaningless, my lord. But your lordship can see the impugned order.
What
The
impugned?
Revenue Divisional Commissioner, my lord, in Sarat Appeal number 2 of 2022, Annexure 3. Your lordship can see the operative portion. He was allowed by
And
that
who
order.
is this Umakant Boisai?
I am appearing for the Umakant Boito. He is added as opposite party number 2, madam.
So let him file affidavit. He is seeking
Your
time.
lordship also directed the state government, your lordship, a very strict one, that you should take the instruction, your lordship's order dated 8/2/2024. Your lordship's order.
No, but that was, we were not aware about this order of the subsequent 26/4/2024. The subsequent development.
Coming up after 1 year, this case is coming up after 1 year. So
After 1 year.
what has happened, we have
In the meantime, my lord, though the period has been expired, that opposite part number 2 has been allowed to operate the side of my lord without having the very glitch.
When this order was passed on 8/2/2024,
Sir, I am not aware of that order. I will go to that order. Your
we
lordship.
were not aware of this writ petition.
This on the every.
Who you are representing in council appearing on behalf of the respondent number 2, opposite party number 2 seeks and is granted 3 weeks time to file counter affidavit. Let's this matter on 3 weeks. So, meanwhile, the state opposite parties shall also be at liberty to file affidavit.
Yeah, Mr. Samantra.
Your lordship fixed up a date.
Yes.
Yes. Item 25.
Now a counter affidavit has been filed by the state for controversy of the parity.
Friday we have filed counter affidavit, my lord.
Yes.
Friday we have filed counter affidavit.
That has also come to the records.
That has come to the record.
So point is, so far as I am trying to include your lordship on some preliminary questions subject to your lordship's acceptance. In fact, petitioner was promoted by virtue of a notification dated 5/8/2017 to the super time scale. And he joined as a Registrar General of this court on 5/6/2020. 5/6/2020, Registrar General. Then at this juncture, may I take your lordship, the entire the crux of the matter is this. Kindly come to page 59. Page 59. Page 59. Turning page 59.
Yes.
Yes, let's get it. This is the note sheet which was placed before the petitioner, who was then as the Registrar General, by the Deputy Registrar Judicial on 26/12/2021. 26/2/2021. I'm just reading that. The Registrar General, this was Registrar General. The Honorable Division Bench of the Honorable Justice Swanso, by order dated 24/2/2021 has observed as follows, quotation. The Odisha Reservation of Post of Service of Social Educational Backward Classes Act 2008 regarding reservation of ACBC category has already been quashed by this court in the judgment dated 29/6/2017. ACBC category is still going on in respect of advertisement issued by the state government, public sector undertaking, and even by this court. In the meantime, 4 years have already passed. Now, and no further legislation was made by the state government as stated above, and it is continuous cause of action, and the state functionaries are violating the court's order. Since it came to the knowledge of the court that said reservation is still continuing without taking further step by the government, this court initiated a suo motu proceeding impleading the state government as well as registered judicial of this court as opposite parties and engaged Mr. Buddhadev Rautal and senior advocate, Mr. Manoranjan Mahantil and senior advocate, Mr. Ashok Kumar Mahantil and senior advocate as amicus curiae to argue the matter. The name of the learned amicus curiae be reflected in the brief as well as in the cause list. Issue notice to the opposite party at the Chief Secretary, Government of Orissa, Bhubaneswar, Principal Secretary General Registration Department, and Registered Judicial Orissa High Court. Learned additional government advocates shall accept notice on behalf of the Registered Judicial Orissa High Court cadre and shall file counter on his behalf. Counter be filed by the opposite party by 15 March 2025. Next line is very important. In this connection, the copy of the order dated 24/2/2021, copy of the order placed at flag A may kindly be perused. It is pertinent to mention here that there is no nomenclature as suo motu proceeding. Hence, in view of the kind order of the Honorable Court dated 24/2/2021 flag A, a suo motu repetition may perhaps be initiated citing registered administration as the petitioner and impleading the Chief Secretary. There's 59.
Yes, sir. Please, fine.
Yes. I'm reading the last paragraph. Quotation of the order. It is pertinent to mention here there is no nomenclature as suo motu proceeding. Hence, in view of the kind order of the Honorable Court dated 24/2/2021 flag A suo motu repetition may perhaps be initiated, citing registered administration as petitioner and impleading the Chief Secretary, Government of Orissa, Bhubaneswar, Principal Secretary, General Administration Department, Government of Orissa, Bhubaneswar, and Registered Judicial High Court as opposite party. Place for favor kind consideration for others. To the register, this is the note sheet was placed before the Registrar General. But we come to the next page, that is the order, which was also along with the note sheet. This is the order, unsigned order, which was also placed, and the quotation from that order, dated 21/24/2021, at page 60-61. Then you also may kindly come, page 62. After this, so-called explanation was called for from the petitioner on 5th April 2021, that is at Annexure 4 at page 62. Page 62, running page 62. From Registrar General High Court of Orissa, by that time he was transferred. The then Registrar General High Court of Orissa to Sri Maharajan Das, District and Session Judge, Rayagada, sir, I have been directed by the Honorable Chief Justice to seek a written explanation from you in the matter of registration of a suo motu writ petition number so-and-so during your tenure as a Registrar General. Copies of the document enclosed with the letter reveal that the said writ petition was registered on 26th February 2021 on the basis of an unsigned judicial order dated 24th February 2021 under your instruction, approval as the then Registrar General of the Court. I am further directed to request you to send to me within 7 days from the date of receipt of this letter in writing all the facts within your knowledge, and explain why and what circumstances the suo motu writ petition came to be registered. Now, at this stage, you also look to my reply. These are all matter of records and admitted. Page 74, this is my reply to the explanation. Then your Lordship will, I will place putting my issue to be decided by your Lordship. Page 74 at Annexure 5. That's my reply. This is admittedly these are on records to the register. Explanation in the matter of registration of suo motu WPC number so-and-so on referring Honorable Court confidential letter dated 5th April 2021. Sir, in obedience to the direction of the Honorable Court and with profound respect, I humbly beg to submit my explanation here below regarding all the facts within my knowledge and as to under what circumstances above referred suo motu writ petition came to register. 1. On 26th February 2021 at around 6:30 p.m., the Deputy Registrar Judicial of the Honorable Court placed a note sheet before me and asked to approve the same in order to comply the order of one division bench of the Honorable Court on the ground that the compliance of the order was to be done on that date itself, and the same could not be done unless a case was registered. Since this type of matter does not come to the undersigned, on my query, the Deputy Registrar Judicial clarified that as the Registrar Judicial was directed to be arrayed as an opposite party, the matter was not put up before him as was being usually done in this type of matters. And paragraph. In the note sheet, he had quoted the relevant portion of the order and also informed that as per the direction, copy of the order was to be supplied to the learned senior advocate engaged as amicus curiae by 26 February 2021. That is on the date it was put up before me for approval. He also ordered that the brief along with the order was to be supplied to the amicus curiae on the same date, and thus it required immediate registration for compliance of the order. I approved the note sheet by oversight under the impression that the file was in order. Adding to my misfortune, the Deputy Registrar Judicial did not brief me that he had placed the note sheet basing on an unsigned order, as it enclosure B of your kind letter. And even I could not focus my attention on this part of the order. On good faith, with an honest intention to comply the order of the Honorable Court in promptitude, I approved the same, which is an inadvertent mistake in my part. I may humbly submit here that since the note sheet along with the order was put up before me by a competent officer of the register, I even could not sense that there was dissenting opinion of one of the Honorable Judge of the bench. The note sheet was placed before me after 2 days of the date of the order, and also the same did not contain that part of the dissenting order. I may further humbly submit that the Deputy Registrar Judicial of the Honorable Court reported that he took instruction from the Honorable Judge presiding the Honorable Bench that Register Administration of the Honorable Court would be the petitioner. As I was skeptical about such fact as to whether the Register Administration would be the petitioner in case where the Registrar Judicial was directed to be one of the opposite party before approval of the note sheet, I sought instruction over phone from the Honorable Judge presiding the bench regarding this aspect, to which her ladyship instructed to put Register Administration as the petitioner, and for any changes if required subsequently, the Honorable Bench would take care upon hearing the party. At that time, her ladyship did not inform me about the dissenting opinion of the Honorable Judge of the bench over the matter, and that the said order was unsigned one. I may humbly submit here that as if at that point of time I could focus my attention that the order was not signed, or it could come to my knowledge that was dissenting view of one of the Honorable Judges of the bench, instead of approving note sheet, I would have definitely and instantly applied the same to the Honorable Chief Justice for seeking his Lordship's kind instruction in the matter, under the bona fide impression that the same was merely about the registration of a suo motu proceeding based on a judicial order. Next page. I did not feel it proper to bother Honorable Chief Justice in this matter, and cursed with bad luck, I routinely approved the note sheet on good faith. The same was an error of judgment on my part, being persuaded by an honest intention of compliance of routine judicial order of the Honorable Court, which was placed in the last hour of the day when I was almost exhausted. Para 6. I may further humbly submit that since the date of my joining in this judicial department, I have always discharged my duty with utmost humility, integrity, devotion, and dedication, and tried to uphold the dignity and majesty of the institution throughout. During my tenure as a Registrar General of the Honorable Court, I have also worked with the same passion and principle, with all sincere commitment toward the Honorable Chief Justice and his care and noble interview. In such background, I earnestly, on unconditional, beg apology for such unword happening caused for the first time in at my instance, and promise to remain careful in future and further pray with folded hands that my case may kindly be considered leniently and compassionately. I therefore request you to consider the expression, please be placed before the Honorable Chief Justice. That shall kindly come to page 82. The memorandum of charge was framed thereafter. And what is the memorandum of charge? That's relevant, that starts with page 80, but I'm taking to page 82, that starts with the article of charges. Page 82, running page 82. Whereas you see so and so, let's skip over. Charges were gross misconduct, dereliction of duty, administration of indiscipline while dealing with judicial record, 4. Failure to maintain absolute integrity and honesty. Of course, this integrity and honesty has been exonerated subsequently, but these are the only allegations. The above charges are based on the following facts. 1. That you, while working as a Registrar General, High Court of Orissa on 26 February 2021, without making the Chief Justice informed, approved a note of the Deputy Registrar Judicial and thereby instructed for registration of a suo motu proceeding on the basis of an unsigned order bearing 24th February 2021, purported to be of a division bench of the Honorable Justice so-and-so, though you had no authority under the rule of the High Court of Orissa 1948 to issue such instruction. That your instruction and approval for registration of the suo motu proceeding so that you had acted on a validly signed judicial order passed by a division bench, by the division bench of the court, though in fact there was no such signed order available in the record. You being a judicial officer, you will fail to appreciate that an unsigned order carrying direction for registration of a suo motu proceeding was not to be acted upon without the approval of the Chief Justice. That on the basis of your instruction approval, the Registrar of the High Court registered suo motu writ petition number so-and-so, invited Registered Administration Orissa High Court versus Chief Secretary Government of Orissa and others, and sent notice to the opposite party enclosing copy of the above unsigned order. Office of the Advocate General Orissa received the notice, and a copy of which notice also received by the office of one of the amicus curiae, Mr. Manoranjan Mahan. The next page, that the above act and omission of your lord, the majesty of the High Court, and it amounts to gross misconduct and dereliction of duty and administrative indiscipline, thereby you maintain absolutely. With this period, I myself, with my limited knowledge, I have prepared a short note. So, for the what are the issues and what are the law laid down by the Honorable Appellate Court in this regard? So, let's make kindly have a glance. I have prepared only 2 pages of what are the issues. Then the judgment I refer to in each of the issues. If you Lordship will appreciate this, that's all right. If you Lordship will sorry. The issue for this determination.
Yes.
Yes, I've given the issues. Let's see that the issues I have framed on my own, whether the first issue is whether the charges and allegation of misconduct, basing on which the disciplinary proceeding has been initiated, can at all be construed to be misconduct. Then 2, whether in absence of any allegation regarding deliberate intention of the petitioner, can it be treated to be a misconduct in the eye of law so as to proceed with the imposing major penalty? These 2 judgments I have referred to as look to 2 judgment. First is this 2007 4 SCC, page 566, paragraph 10 and 11, that you also turn to page mark. The first judgment, it comes, starts from page 4. Page 4, it also will come to paragraph 10 and 11. That is at page
What happened to the Deputy Registrar?
Yes, that is also a ground that though proceeding was initiated against both the then Registrar General, Judicial in charge and the Deputy Registrar, one of them has been exonerated. On the same, though that was also unsigned order, which was also same allegation was made against.
The Deputy Registrar has been exonerated.
Little, there is a less punishment has been
inflicted.
Withholding on one increment. So far, the legislation is concerned. And the other.
Please take your seat, Mr. Please take your seat, Mr.
Sir, you must kindly come to paragraph 10 and 11 that starts from page 10. The first judgment that starts from page. Yes. That is page 8. Running page 8, paragraph 10.
Yes.
Yes. As your worship rightly put that question, whether they have been exonerated, registered judicial in charge who placed the note, he has been exonerated. He placed the note with that on sign.
This is what.
Yes. Yes.
So who has been punished with?
Deputy Registrar with a very lesser punishment.
Deputy Registrar had placed the note.
Initial
the registered judicial in charge. He recommended the matter to the registered judicial.
Recommended, where is the
Yes,
recommendation?
that is there.
No, what punishment has been imposed on the Deputy Registrar Judicial?
Only increment.
Only one increment, possibly one increment. Like I'm saying, only one increment.
And what punishment has been imposed on him?
So for the petition is concerned, that you actually look to that. That is at page 185. Major punishment. Page 185. That comes at page 186 at Annex 23. In pursuance of the notification dated 21/12/2022 of the High Court of Orissa, Cuttack, the pay of Madaranjan Das, ex-Register General, High Court of Orissa, Cuttack, at present, presiding officer, Industrial Tribunal, Raurkela, whose pay has been fixed as per the Law Department resolution dated 26/10/2022 in the cadre of District Judge in the revised judicial scale of 2022 at 1,72,960 in cell number 3 of level J6 selection grade of the pay matrix with effect of 1/1/2016 with next increment due on such and such date, cell level 7 J7 super time scale of the pay matrix with effect from 3/8/2017 with next annual increment on 1/8/2018 by Home Department Office Order 15/12/2022 is refixed in the cadre of District Judge in the revised judicial scale of pay of 2022 at 1,63,030, cell number 1 of level J6 selection grade of the pay matrix with effect on 21/12/2022 to next
reduction in pay scale.
Yes, reduction in pay scale again also. Next annual increment will be due to him with effect on 1/12/2023. Then 3. The upgradation of Sri Madaranjan Das OSJS to the next higher grade in the super time scale will be considered after 5 years from date 21/12/2022. Then the payment of arrear on account of fixation of the pay of the officers concerned in the revised judicial scale of pay shall be regulated in the and he was in the petition was in the super time scale. Now the penalty initial grade pay of the he has reverted. Then after 5 years he will be considered for the super time scale. That is what the punishment has been awarded at Annexure 20. Then I'll take a to the judgments. And we come to page 8. Deputy Registrar. One increment of
Mr. Rautray.
Yes, ma'am.
Sister Savitri is pointing out that she was a member of the full court. There is no difficulty.
No difficulty.
There are decisions of
the court. Judicial
it can be entertained. But will it not be proper if a bench is constituted, can be constituted if you want, if there is some urgency and if there is urgency.
So I can't.
So that can be constituted.
One of the grounds taken by you, something like that. That is what it up.
So we can take up the matter on say on Friday. On Friday or on Thursday we can take Thursday we can take up the matter.
In fact, I remember in case of Evira, I might talk about this. Justice Indrajit Mahathi was a party to that full court decision. Not only party, he had also signatories of recommendation. But while hearing the matter, this question was raised. But both of their worships referring to some judgment, while hearing a judicial side.
Absolutely right. We don't have any difficulty about that.
For your worships.
That is
every son, the full court takes a dissent.
Yes. That is law. That is law. That is law. That is absolutely law. But since we have, otherwise, see, if all the judges are members of the full court.
Right.
Then where will the matter go? Will it go only before the Supreme Court? No, the Supreme Court has laid down in so many cases that the administrative.
And in fact, I was trying to find out, in this case, possibly subject to your lordship's acceptance, the then Honorable Chief Justice is a party in every stage, not only initiation, but every stage. Then question comes to my mind, if the Chief Justice is a party to the full court and full court has taken a decision, then how can you say that the Chief Justice cannot? But there are some judgments that if every stage he should. I listen myself to.
Like, yes, subject to my lord's appreciation. My lord's, we have from our side, Lord, we have objection, my lord.
So it will come on Thursday.
Thursday will do.
With
Hello, oblige.
Put this matter on Thursday before appropriate bench, after obtaining necessary orders from Chief Justice.
Right.
Item number 26.
Presently, last order passed by Lordship 10/12/2024, wherein the Lordship had heard the matter at length, and your Lordship was pleased to.
And your Lordship has forgotten everything after hearing the matter at length.
Wherein, admittedly, your Lordship, the private opposite party has scored less marks in the recruitment process of assistant section officer than the appellant. But by purporting himself to be a sports person, he was given recruitment while the appellant was not given, in spite of being more meritorious than the private officer. The last occasion, your Lordship had directed the state as well as the OPSC to file two separate affidavits stating the reason as to why recruitment should not be granted to the appellant.
Lordship directed to us to file counter. My lord, I have called the officers. They are coming today. I will prepare the affidavit and will file by Monday. Lordship, I called this matter on 15th. 15th, I will file affidavit. For OP number 1 and 2, my lord. For OP number 1 and 2, I will file affidavit. Respondent number 1.
Who is respondent number 4?
The necessary affected person.
Yes, who is for the Orissa Public Service Commission?
Nobody yet has appeared for OPS.
Because you had accepted notice on behalf of OPS.
No. 1, 2, my lord. 1 and 2. Respondent 1 and 2.
The first one. You have accepted on behalf of OPS. What did you do with the copy? On 13/3/2024, the MK Kuntia accepts notice on behalf of respondent 1, 2, 3.
That might be
What did you do
mistaken.
with the OPS's notice? What did you do?
That might be
If you
mistaken.
have appeared, you have to file the counter.
No,
Please look at order dated 13/3/2024.
You may be permitted to communicate the OPSC to file counter.
No permission is necessary. This is your duty since you have accepted notice
Okay, all right, we'll communicate.
1 year back.
We-
this matter tomorrow. Land Council, who generally represents Odisha Public Service Commission before this court, is requested to be present tomorrow when the matter is taken up. Yes, please inform him.
The Tripathi or who appears for this?
Please inform Mr. Tripathi. Whosoever.
I'll inform both. I will inform OPSC.
Please inform.
Yes,
Because-
they will engage their counsel.
These are Mr. Panda and AGA undertakes to inform the officials of the OPSC also. And also is to about dependency of the present rate application. Yes. So
Item 27.
Last year, my director to government to the instruction.
yes.
Lord, in this case, they relied on the judgment of Gokula and the Panda State of Odisha and others. That judgment still holds good, my lord. Because in the case of appointment and seniority and all that, that cannot be challenged by the education tribunal. Rather, that is a decision to be taken by the governing body of the institution. That is the law setting. And hence, in that case, because the governing body has not considered, education tribunal has taken the decision that was squashed, as the matter was directed, matter was sent back to the director, secretary of education to determine the issue. That is the law holding the field as on today. So, governing body of the college, managing committee of the school has the authority to decide the issue related to the seniority, appointment, and all that. The judgment was passed from the Lordship last date by the advocate of the petitioner that the Gokula and the Panda were the state of Odisha and others.
Where is the impure order?
Passover, Passover.
Where is the order passed by the learned single judge? Annexure 3.
Page 1.
Annexure 6.
6, sorry. On 73, with T of the judgment, there is observation value. Tribunal, single judge, they framed some issues and sent it back to tribunal for decision.
You are for the appellant. You are not ready at all.
And for lesson number 7, 4.2, this honorable court has claim issue. This honorable court has claim issue 173. It is continued that may I please know?
Here, he cannot assist today. I requested all.
It's not note I given my.
This matter tomorrow. Yes.
Item 28.
Next week.
Tomorrow.
Tomorrow. Right.
Fast. So these metal items, can it do fast day?
Okay, all right.
Item 28.
State has filed a counter affidavit on 17/12/2024, seeking for 7 more days to file rejoinder.
And counsel for the petitioner seeks adjournment to file rejoinder to the counter affidavit filed on behalf of the state of Orissa. Is this matter on? So as read for. Yes. Many. How much time? 1 week? You
1 week.
1 week.
Item 29.
Two weeks.
Item 29.
29, that's 2 weeks. I may be granted to file rejoinder affidavit.
Time order.
Item 30.
This is more of a
doing that, my lord. Yes.
something.
My lord, we have approved the mining plan. Matter is pending before the statutory authority for according statutory approval.
Environment clearance.
And environment clearance statutory authority that I have written a specific letter for expedition of the process because of the public interest involved. And they are considering and lordship may dispose of the matter directing the statutory authority to consider expeditiously so far as according the clearance is concerned.
How much time will it
Everything
take?
from our side has been completed in the meantime, Lord.
Who has to do it now?
SIA, that is a State Environment Assessment Impact Assessment Authority. State Environment Impact Assessment Authority.
Oh, how much time do they generally take?
It is generally 1 month. 1 month. Yes, it's 1 year.
1 day, 2 days, it depends on the.
How can
Depends on their sequence.
Anyway, lordship, expeditiously, your lordship may.
So have you brought on record your decisions?
Yes,
Where is that?
I have filed a specific affidavit, which is, my lord, in reply to the affidavit file. In that, I have stated that that reply to the affidavit dated 31/12/2024.
31/12.
Yes.
Is there? For 21. Yeah. Oh.
Para number 27, your lordship may kindly have it.
Filed by Deputy Director of
Yes,
Mining Charge.
Yes. He has approved the mining plan. Paragraph 27. Paragraph 27.
That's para 34 of the.
34. And 27. That is.
So they can start mining operations as per your paragraph 27. You have said that the petitioner company has to show its bona fide and commence mining operations.
No,
At the earliest time.
there are
Then
about
they can start.
34. 34 conjointly, your lordship must be 34. Para 34.
28, you say that you would provide approach road
Yes,
before
That
joint verification.
that we undertake. That we undertake.
That you would provide the road before joint verification. Good.
No, understood. To
We
provide
have not yet provided the road. They will provide the road. That is the undertaking in the affidavit.
Yes.
But so far as environment clearance is concerned, my application is pending before the CR authority.
No, but the things have been done. In fact, your grievance has been redressed.
They are taking steps. My train.
They have taken
this
steps.
side, there is no difficulty.
No,
Only
even the
authorities are
state
not
have,
taking
the
steps.
state officials, in fact,
May I frame that since data taking is pending, they are taking steps. May I frame let this matter be taken up 13th or 15th. What action they have taken during this period?
CR party.
Yes, no, CI is not a particular, it was not the dispute earlier. Dispute earlier, my lord knows the.
used to engage their own counsel, my lord.
But they are the government authority, all the committee members are government officers.
State government authority, that's it.
All the officers are government officers.
Autonomous institution.
That's a different
That is not
entity,
under the
Mr.
state control. It's not under this. They used to engage a separate counsel.
list this matter on 15. When the court shall pass appropriate orders in the light of the affidavit filed on behalf of the state of Orissa on which date 1712.
31/12/2024 by the OP number 4.
31/12/2024 by
31
OP number on behalf of OP number 4. No, paragraph 34 of the said affidavit reads thus.
About that approach road.
Approach road they will provide, they have.
Stated in the affidavit, my lord, that they will facilitate. That is paragraph 28.
Paragraph 28. Paragraph 28 of
Undertakes
which
to provide such approach road to the petitioner.
No, but.
paragraph 27, 28 and 34 of which read thus.
Joint verification will proceed or
It will be dispute free.
Depending upon the development on the petitioner's application for grant of statutory environment clearance by the State Environmental Impact Assessment Authority. First off, let a copy of this order be communicated to the State Environmental Impact Assessment Authority. Can you do that?
I have already written the letter. I will also comply with my lord, communicate the order.
By learned AGA. Let us see.
I think hopefully everything will be done.
Everything has been done, except that matter is pending before the.
Hey, you are putting in 15th, it will be and Mr. Panda has also taken some
So
initiative.
public interest, sometimes we.
Item note 31.
Lordship, it is a matter about the mega apiculture project. Mega apiculture project, beekeeping. And let the opening shows that the petitioner has filed a rejoinder to our affidavit, counter affidavit. The copy of the rejoinder affidavit is not.
Have you given?
Yes, already copy solved. Copy solved on
Give him a copy.
2024.
Give him a copy.
The copy received or the
Yes, copy received. Copy received. Already filed in the.
Just show him so that he can trace it out.
It is stated by an AGA appearing on behalf of the state that presently it does not have a copy of the rejoinder affidavit filed by the petitioner. You file it online.
Online.
Right online.
Yeah, it's an online. So this matter on 2 weeks so as to enable an AGA to consider this a rejoinder. Let serial number. There is a typographical error while recording the serial number of order 2/3.
Plus 3 1. 2 or and 3 or 2 3.
21/3. Serial number of order
2 and 3.
01. Sorry. Okay. Serial number of the order has been wrongly typed as 1 instead of 2. It's proper. It's necessary correction we carried out accordingly.
Item note 32.
Please, in appearing on behalf of Mr. Mitra. My lord, the state has not filed the counter affidavit. So let them file the counter affidavit.
File it.
We have already filed the counter affidavit, your Lordship. That's on record. That's on record.
But have you served a copy?
Yes, sir.
This is counter affidavit.
State has not filed it. I have filed on behalf of the corporation.
State is necessary.
No, madam, he says, madam, he says state has. My state is that the entire action is being done. The central government scheme is implemented through state government by the corporation, because corporation madam has been created for the purpose of all these work. So state may have a say in the matter, madam. It can't be said that state is completely excluded. With regard to this policy, because we have made a policy where these vehicles which are moving will be monitored, but there has been misappropriation and all those things. So that is being questioned. So therefore, state will definitely have a say in the matter.
See. So you are asking for time on what ground?
The ground that counter is not.
He is saying state has not filed counter. That's what he said.
State is required to file counter affidavit. Why are you worried?
Let it come.
He is not saying whether he requires a rejoinder or not. That he is not saying.
He is saying what he has been asked to say, what will be. Yes. Have you read the brief?
No.
How will you learn if you don't read the brief? golden opportunity for you to learn. You are not reading the brief, you have been sitting there. What is your name?
Ambaris Misra.
When did you join the bar?
Last month.
Okay. You senior may conduct the case, but you read the brief, right?
Yes. Requested by learned counsel. On behalf of the petitioner, discuss matter on 2 weeks.
Item note 33.
I filed my rejoinder last day.
If I.
No, count that.
When?
I would actually.
When? Mr. Masti, when did you serve it?
On 3rd of this. Amalata, the receipt is being shown to me, that is the counter receipt. Our High Court company. Counter take.
The 1/2024, there's a rejoinder affidavit. 3/1 means obviously one day we can't expect. You must have served on Friday.
I will check out.
You check, if not fine, give another copy.
Yes.
I'll serve another one.
Better. Yes.
He'll serve
He'll serve another. I'm saying he'll serve it here. Confidence for answer. What is this matter?
No, this matter is relates to that the petitioner being a successful bidder has fulfilled all the necessary conditions. Despite of which the agreement was not executed. Now, in the rejoinder affidavit, the lordship may see have annexed the document order of the collector, wherein similarly placed.
Similar is different, but
Your
counter they are saying.
No, your lordship may see the rejoinder.
Rejoinder, he says yes, down on Friday. We can't expect them to tag it in one day. Friday, today is Monday. So he's targeting to serve another copy. Both of the day.
In course of
2 weeks. Top, let a copy of the rejoinder affidavit filed on behalf of the petitioner be served upon and AGA by tomorrow.
in course of
Yes.
Item 34.
next week.
2 weeks.
Okay.
If referred.
Water.
Water may be difficult.
Next week, not anything.
Next week is what?
Next week starts in 30.
13.
Any
You can try on 16th. 15th.
Item 34.
Yes.
Lordships were pleased to direct the opposite party to dispose of the annexer 5/1 within a period, my lord. In the meantime, my lord. But my lord, the Tahsildar is not a party, and the mining officer says that he is not equipped with the, my lord, having the records. Therefore, I have issued letters to the Tahsildar and called both of them.
Supposed to file a counter affidavit within 4 weeks.
My lord.
They granted you liberty to dispose
Yes,
of.
yes, but
So where is the counter affidavit?
if we dispose of that application, my lord, the matter will suffice. Ma'am.
Not dispose of.
Therefore, I have called both the officers for filing an affidavit, and in the meantime also will ensure disposal of the annexer 5/1 because the mining officer is not having the records and Tahsildar is not a party. I have asked both of them to
my lord, to come to my office.
See, if the state of Odisha is a party, there is no question of Tahsildar or absence of Tahsildar.
Records, because of the bifurcation, my lord, that records are now, earlier it was the competent
No, I have verified, my lords, from the Tahsil office. The records they say are not available, and besides, he has no power. So
Yes.
that is why I filed the fresh writ, impleading the mining officer.
Mining officer will pass the order, my lord. I have called both of them and having discussion, both of them, I will file the counter affidavit. In the meantime, also will dispose of the 5/5, Annexure 5/5.
Pass the order.
Yes. After passing of the order, we will file the affidavit, my lord. Because the appropriate authority is the mining officer now.
Then the AGA, does this matter on, how much time?
15, your lordship.
On 15th. In the meanwhile, counter affidavit must be filed.
Yes.
Item 35.
In this interpretation, I have challenged the entire tender process of Ukudakandi CFC, where the NSC, where the on tender process dated as notification dated 6/8/2024. Because I have not published the power of attorney, my bid has been cancelled. That's all.
Mr. Counsel, this, you had made a mentions, file a mention slip. And the order was put up in this second week of January. All right. Yeah, what is the matter about?
Matter, I have not furnished, though I have not furnished the power of attorney details in my tender paper. So I have a single proprietorship organization. And I have submitted the entire document as required by the Ukudakandi NFC minor. But though I have not furnished the power of attorney, because I have a single proprietor, no other person is there to whom I will supply the power of attorney. For that reason, my bid has been rejected by.
What is this? State. You are appearing for?
I am for
Another municipality.
For the
notified area
municipality. How
council
can you
must
do
go to
it?
the tender allotment.
See, why, how do you require filing of power of attorney in each and every case?
My lords, that has been considered.
Then-
That document has not been furnished by the petitioner lordship. I have filed a counter affidavit. My lord may kindly take up the counter affidavit.
When did you file?
Filed on 28/11, your lordship.
Oh, all right, yes. Have you seen the counter affidavit?
Yes.
Yes, which paragraph?
My lord may kindly turn to page 48, the document itself, your lordship.
Annexure 3/2.
Your lordship,
Yes.
page 48, my lords. Proceeding of the tender committee meeting. May I place that, your lordship?
It is in Odia or English?
It is in English, your lordship.
Huh?
My lords. Dated 26/9/2024, the tender committee meeting of NSC Bhanjanam, NSC is notified area council, your lordship.
And what is?
Was held on 26/9 at about 11:30 for financial evaluation of tender reference number such and such. By tender call notice number such and such. My lord, may kindly come to the middle of that paragraph. The technical evaluation finalized by the tender committee.
Oh, your technical you have been found to be.
My lords.
Is because
Financial is where the petitioner fails, your lordship.
Well,
And this has already been informed to the petitioner, your lordship, on that very day.
Yes, why are you saying?
Madam, petitioner has not intimated my about the entire. Let me take instruction.
What instruction? The counter affidavit was filed.
but this was not communicated to the petitioner. The counter you have.
Yes, madam, I have
communication.
communicated, but he has not
Instruction
instructed me
means,
anything else.
you have not gone through the counter affidavit.
We are disposing it off.
Kindly depend on Monday, I will instruct.
As requested on behalf of the petitioner, this matter of. Next.